All right, you're still watching SA Today, and we continue unpacking the story, of course, today, the Constitutional Court's judgment against the Public Protector. And to help us understand what happened and what it all means, I'm now joined by attorney Ulrich Roux. Thanks so much indeed for joining us. Welcome to the program.
Thank you for having me, Peter.
All right, so just how significant is the decision that we heard today by the Constitutional Court?
Well, it is a decision made by our apex court in our South Africa. It is the highest court in the country, and the decision cannot be appealed, it cannot be taken on review, it cannot be set aside. So pretty damning for the Public Protector. You know, the judges were quite scathing in delivering their judgment, in saying that it seems as if she acted in a mala fide way, which is with ill intent, as well as taking it further to say that she was dishonest under oath. Which has far-reaching effects for her as well as an advocate of the South African bar. So, you know, I think a very damning judgment, and one that will be recorded as well. Remember that all Constitutional Court judgments are recorded. In other words, they are used in developing our law going forward. So this could have the effect that any future judgment or reports issued by the current Public Protector can be scrutinized using this judgment.
All right, so they talked about falsehoods. They're actually saying she lied under oath.
Indeed, yeah. They say that it was proven in the papers before the court that she did lie under oath, that she deliberately did not include certain information, and that her version and her report, as she put it forward, cannot be believed, which is very damning.
If she was just an ordinary citizen like me, lying under oath, what penalty does that carry?
Well, there is the criminal act or charge of perjury, and perjury is where a person perjures themselves. So in other words, they depose to a statement under oath, or they give testimony under oath, where they guarantee that they are telling the truth and that there is no dishonesty or falsehoods contained in their statement and their testimony, when in fact it is then proven later on to have been false, and that the person was in fact dishonest under oath. It could very well carry a penalty of imprisonment, although that is not very often seen in our courts. It does not carry a minimum sentence, but more importantly, for a person such as her and in her position, it is very damning for her credibility, because she is an advocate in South Africa, and also she's the Public Protector.
Right, and then the council, I forget the full name of this council.
The Legal Practice
Council. Their job is to make sure that only fit and proper people are able to practice law as an advocate or as attorney. And I just wonder, with this on their desk, they must feel compelled to take some action. They can't just leave it alone.
Yes, definitely. So the Legal Practice Council will now appoint a committee to look into the allegations. If there's a valid complaint that's been laid against the advocate, which it seems there is, then it's their duty to investigate it, and it's their duty to report back to the complainant to say what their findings are. They've conducted further investigation, and then either the matter can be referred to their disciplinary committee for them to adjudicate it, or one would have to see what the Public Protector answers to the allegations. The next step would be, if the Legal Practice Council has made a finding, and say for argument's sake that they do find that she did lie under oath and that she's not a fit and proper person to be registered as an advocate in South Africa, then the Legal Practice Council could launch an application in the High Court of South Africa to have her struck and effectively removed as an advocate on the roll, which would obviously have very, very severe consequences for her career, but also for her position as a Public Protector, because you know, one would struggle to see whether she can remain in that position. Yes.
So can the President, for example, use this judgment to say, this is the woman that's coming after me, this is the woman that's laid these charges against me, and this is why I feel that I've been treated unfairly?
Strictly speaking, no, because the facts in the Absa Bancorp matter are obviously not similar to the facts in her report now, where she's implicated President Ramaphosa in dubious or unlawful actions. But the decision made by the Constitutional Court is binding on all other courts going forward. So if they do argue in front of a high court and her report is taken on review, as the President has now indicated he is going to do, then they could very well refer to findings made by the Constitutional Court when it scrutinised certain of her actions that she took in the Bancorp matter. There must be direct correlations though, but to take it one step further as well, our courts and the judgments that are handed down by our courts develop our law on a daily basis. And this is certainly a binding decision which will be binding future courts making similar decisions of this nature.
All right. Perhaps finally, if we could just go to the President's situation. Depending on who you listen to, who you read, some are saying that the Public Protector's case does have some merit, and others are throwing it out completely. What's your take that there must be some middle ground there that takes a bit of both?
Well, unfortunately, they're saying that where there is smoke, there's fire normally. But having said that, one would have to look at what the review application entails. The Public Protector is entitled to compile a report, as she has now. She must, however, confine herself to all of the guidelines contained in the Public Protector Act and what her duty entails, and she must do her job properly in accordance with that. And if the President now takes her decision on review and a report, and he can indicate that she disregarded certain information, that she was dishonest in certain instances, that she completely misappropriated the facts in the matter where she implicates him, then definitely there is merit in his review application. But just as the Public Protector has now approached the Constitutional Court, the President obviously has a right to approach the High Court to take a report on review, and we'll have to wait and see what that review application entails, and then ultimately what the High Court finds, whether the Public Protector acted in accordance with the Public Protector's Act, and whether the report that she submitted can be taken as being the truth and taken as being an accurate reflection of what happened.
All right. Look, I don't know how much you know about what happens inside the Public Protector's office, but I would imagine there's a team of lawyers in there, and she's being held personally liable. But shouldn't the whole group be taken on, because they surely work together?
Well, we deal with numerous Public Protector matters. We represent numerous clients who we have assisted in approaching the Public Protector's office, and at the end of every report being issued by the Office of the Public Protector, it is signed by the Public Protector. So she binds herself when she signs that document, and she binds herself as being the person who ensured that whatever is contained in that document is an accurate reflection of the Public Protector's investigations launched into the specific incident. So unfortunately there's no escaping that for her. It's damning where a person in their personal capacity has now been awarded costs against them, because she can't go now and say, well, it's the taxpayer must pay for this, because she signed off on that report. And if she hadn't, then the parties who took the matter on review would not have incurred all of those legal costs. And that is why the court said, if she had just done her job properly, then it would never have been necessary for the banks to take it on review, and they would have never incurred those costs. So she effectively has caused directly through her actions that they incur these costs, and thus she must be held liable. Very damning for a person in her position. Just on a last note, I do think that we were used to quite a high standard having been set by Thuli Madonsela, and those are big shoes to fill, and I do think that the current Public Protector unfortunately has shown that all of her reports have been littered with scrutiny, and I think it's a matter of time before we might see a new Public Protector come into office.
All right, Ulrich, we'll leave it there. Thanks so much indeed, as always, for coming through and helping us make sense of some of these tough legal decisions. Thanks so much indeed for your time.
Thank you for having me.